Good morning. I am delighted to introduce the next panel, Provenance and the Law. My name is Pierre, Valentin. I'm a partner at Constantine Canon. I'm the head of their art law department, and I'm also the chair of ICRA. It's a great pleasure to welcome our panelists this morning, Martin Wilson, Olivier de Baecque, Nick Maclean, and Amelia Brankov. I would like to suggest that perhaps each of them introduce themselves in a few words. So I'll start with Martin.
Hello, I'm Martin Wilson, and I'm Chief General Counsel at Phillips. Prior to that, I was General Counsel at Christie's.
Thank you, Martin. Amelia?
Hi, Amelia Brankov. I'm an attorney in New York. I specialize in art law and litigation at Frankfurt, Kurnit, Klein, and Selz.
Thank you, Amelia. Olivier?
Hello, Olivier de Baecque. I'm a lawyer in Paris. I do specialize in art law, and I represent a fair amount of artist estates.
Thank you, Olivier. And Nick?
Hello, I'm Nick Maclean. I'm a partner of Eykyn Maclean Fine Art Dealership based in New York and London, and I'm also chair of the Society of London Art Dealers.
Fantastic. Thank you, Nick. I'll fire the first question. Are there recent examples of courts opining on what information provenance listings should include or not include, or on how provenance listings should be presented? Martin?
So, in a sense, it's slightly surprising, but there's actually in the UK, in any event, very little case law on this subject. And I think that the reason for that is that the courts tend to just focus on the central issue, which is quite often an issue like authenticity, for example. And what they try to focus on is whether the auction house got it right or not. So it's, in a sense, what they're thinking about is, was the result right, not how did they get there? But we did have one case that came sort of quite close to making a finding, which sort of helps us on this, which was the Thompson and Christie's case. And that was a case in which Mrs. Thompson had bought two urns from Christie's, which were described as 18th century. And so subsequently, the court case tried to examine whether these were indeed 18th century. And in the course of that, looked at the cataloguing. And in looking at the cataloguing, they did look at the provenance information. And some of the provenance information was expressed in early drafts of the catalogue in terms which might suggest a little bit of doubt. So words like possibly were used. And then subsequently, when the final catalogue came out, those words were not there. So the question then before the court was, are they 18th century or not? And the judge at the time found that in fact Christie's was reasonable in concluding that they were 18th century. So they got the decision right. But he then said that they were negligent because the cataloguing had not included all of the information, including the words possibly, which might have given a buyer a sort of false sense of security. So that at that point, everyone was beginning to think, well, here's a judgment which makes it clear that you need to put all of the information into the catalogue. And that, of course, would include provenance information. However, that was overturned on appeal because the Court of Appeal said, look, at the end of the day, if you get the judgment right, in this case that it was 18th century, that's all you need to worry about. And how you set it out in terms of your marketing material is a separate matter.
Thank you, Martin. I would like to mention a more recent case. Unfortunately, I can't really go into it because instead of being litigated, it was arbitrated. But there are facts that are out there in the public domain. And the facts are as follows. In February 2019, so just over a year ago, the Art and General Press reported a claim by a US collector, Mr. Klein, against a leading Mayfair gallery. Mr. Klein had purchased two old master paintings at TFAF Maastricht from the gallery the year before, but sometime later discovered that the paintings had been acquired relatively recently by the gallery at auction for substantially less than he had paid for them. Klein alleged a fraudulent misrepresentation on the grounds that the gallery had deliberately omitted to refer to the auctions and to its own ownership in the provenance listings. The argument made by Klein was that it was implied that the provenance listings represented all the information about those paintings, history in the gallery's knowledge, and included the current owners of the paintings. Klein claimed to have relied upon the alleged false representations when buying the paintings. Now, as I said, it was arbitrated, so the award and the reasons for it are confidential. My firm represented the gallery, but what I can say is that there is an order of the court in the public domain ordering Klein to pay the gallery's costs. Now, as you probably know, in English litigation, the loser pays the winner's costs. So you can infer from that court order that the gallery prevailed. Now, I would like to ask the second question, which is auction houses refused to provide information on consignors and buyers for the last 50 years. Does the law really not allow auction houses to disclose this information to a scholar looking to establish the fullest provenance possible? Olivier, would you like to have a go at that question?
Sure, I will deal mainly with French law. Buyers, in general, buyers and sellers have many reasons to seek confidentiality. They want to protect their privacy, they have tax issues, there are many other issues that justify they don't want this information to be public. And usually auction houses and dealers respect that. If we take auction houses first, in France, you have a code of ethics dating from 2012 that clearly says that the French auction houses have a duty of confidentiality toward their clients. So they cannot disclose their names without authorization. In my view, it's less clear, the dealer should follow the same kind of rules. So what usually happens is that if someone asks for private information on buyer or seller with an auction house or a dealer, the auction house will transfer the question to the client who will decide. Last of all, I would want to point out that provenance is a very important information for businesses, because when you're looking for artworks to buy, provenance is where you find them. So if you, as a dealer, disclose the provenance, you're losing a stream of business, which is very legitimate to protect.
Thank you, Olivier. Martin?
Well, I think it's very interesting, having looked at this from internally from the perspective of the auction house. It was a question that occurred to me when I was first working at auction houses. Where does this 50-year rule actually come from? And I think the short answer is that there is the 50 part of the rule doesn't really exist in law. The part that does is as Olivier said, the confidentiality aspect. So in the UK, it sort of comes from two different areas. One is the obvious one where you contract, and in your contract it says you may not disclose my identity, and you'll see that very often in our business. But equally in the UK, there's something called a sort of course of trading. So if somebody goes to, for instance, a bank, it doesn't really matter too much whether it says in the documentation that they will keep your identity confidential. There's an expectation that a bank will keep your identity confidential. And it's very similar in the UK with auction houses and dealers. And so with time, that expectation morphs into a legal obligation. And so what I think everyone will agree is that there is a duty of confidentiality and a legally binding one. And usually that duty lasts without limit in time unless it says otherwise. So this is where pragmatism comes in for the auction houses, because what they and this is where the 50 year rule comes in, because what they are calculating is that after 50 years, most confidentiality issues are probably not so live as they were before. And so there's a sense of, well, if we're going to set a limit, it's going to be around about 50 years. So again, back to what Olivier said, is if you're asking auction houses for this information and you're told it's confidential, there is a rule, remember also that there are other ways of dealing with it. For instance, a confidentiality obligation can be overcome with consent of the client. So the auction house can approach the client and say, would you mind if we do disclose this information? So it's not absolute. And one final thing probably to say about this as well is everyone will have seen with the new regulatory regime around anti-money laundering, there's greater transparency. And I think that in time will bring with it some greyness around these sorts of rules around confidentiality as well.
Thank you, Martin, very much. The third question, what does the law say about naming historic owners in the provenance, including recent owners who may still be alive? Amelia, would you like to address that?
Sure. So my answer assumes that you have been able to successfully get this information, and the question is, what can you do with it? I think that there are two aspects to the answer, and the first is confidentiality. As Martin explained, if you have an obligation by contract, which can be oral or written, to maintain the confidentiality of the information that you've obtained, then you can't disclose it, certainly not publicly disclose it, without the risk of the person that disclosed it to you coming after you for some sort of claim. So it depends on the source of the information. A lot of this information can be obtained from a dealer, for example. So, I would recommend that in your conversations with the dealer, you make clear what your intentions are with respect to the information, whether it's just to have the information for internal purposes only, or whether you intend to publish the information. You could also get the information from people who are hoping to have their artworks included in the catalog raisonné. And I would recommend that your submission agreement make clear your intentions on publishing the information, including whether you want to give the current owner the option of keeping their identity confidential. And also with respect to the information that they're supplying to you about historic owners, that you make clear that you have the freedom to use that information however you want, and that they're not breaching any duties that they have to anybody in supplying the information over to you. So I think the second aspect of the question relates to data privacy laws. So as many of you may know, in various jurisdictions, there are laws that protect the personal information of natural persons. That includes their name, their credit card information in the US, their social security number. So speaking for the US doesn't really have a robust law in this regard protecting this information in the way that EU consumers have these robust protections. California did recently enact a privacy law providing protection for this information, but it's really aimed at data resellers, and it doesn't even apply to nonprofit companies collecting information. So I think you could safely say that at least for US-based natural persons, they don't, there isn't any risks in violating any privacy laws in disclosing this information.
Thank you, Amelia. You're quite right to mention data protection. And of course, in the EU, we have strong data protection laws. The good news, I suppose, is that under data protection rules, EU data protection rules, personal data of dead, deceased people is not covered. So you can use that data without having to comply with what we call GDPR. However, the personal data of living person is subject to GDPR. We could spend a whole day talking about it. It's rather complex, but I would argue that the author of a catalogue raisonné, who is processing and managing the personal data of living individuals, must comply with GDPR. I mean, without going into too much detail, in order to control personal data, you must have a lawful basis for doing so. And I would argue that there is, for authors of catalogue raisonné, there is a lawful basis. It's called legitimate interest. And that would be the basis on which authors of catalogue raisonnés would rely in order to process the data. But there's much more to it than that. And as I say, you know, we could talk about it endlessly, but authors of catalogue raisonnés should really consider their obligations under GDPR because there are some. Martin, would you like to add anything?
I really, just to echo what you and Amelia have said, I think it all comes back to this question of confidentiality. And while confidentiality binds the relationship between sellers and auction houses, there is a correct expectation on behalf of sellers that their identity will not be revealed. Having said all of that, there are, of course, and perhaps this isn't the issue here, but of course there are many instances where the identity of previous sellers is disclosed because it's either because the seller wants to disclose that information, or because or because it's actually a selling point. But where the client has expressed a wish and expects confidentiality, then of course even past clients are entitled to expect that from the auction house.
Thank you, Martin. The next question is, what are the legal, moral or ethical obligations of the trade to present full provenance to potential buyers? Olivier?
Yeah, sure. Well, the description of works of art has been standardized in France. We have a decree published in 1981. And it contains no clear obligation to disclose full provenance. The Code of Ethics of Auction Houses say that you must verify provenance, but in my understanding, they're really dealing with the provenance of the current owner. So the level of investigation they would have to do in searching for provenance will obviously depend on the situation, high value of work, deep research, suspicious work, many verification. I will give a couple of examples. When you have label on the back of the painting, of course, you verify that the label are correct. If the consignor seems suspicious for any reason, you will verify. So if you're suspicious, you verify. There are indicia of suspicion, like on old books, if you see that stamps of libraries are apparently erased, you have a duty of verification. Another red flag, for example, would be, I had the case, you receive a sculpture from Angkor Wat and you see clear marks of saws. That's suspicious because someone has been cutting the sculpture into pieces. Some legal authors, that's where the discussion lies, say that you have to verify provenance on common databases. Well, it's difficult to have a final point on that because they're sometimes incomplete, they're expensive. So I would once again say that it really depends on the value of the work. I mean, for day-to-day small painting, furniture, you cannot process to deep verification of provenance.
Thank you, Olivier. Amelia?
Sure. So speaking from a US perspective, there's certainly no obligation for an art vendor to supply provenance information, but savvy collectors are generally expecting this. And certainly with auction houses, it's commonplace for the cataloging of a lot to include provenance information. So for auction houses, while they typically give a guarantee of authenticity for, generally a period of 5 years. At the same time, they expressly disclaim any reliance on the provenance information that they're supplying, presumably because they just don't have the same time. They don't have time to vet every lot that they're selling, and they don't have the ability to do this for every lot the way that a scholar would. So I think that's a word to the wise in terms of relying on auction house provenance information. Certainly, I know from firsthand from a case that I brought for a collector that was suing on the guarantee. The work wasn't included in the catalog raisonné, and apparently neither the auction house nor the collector checked this, but the auction house had in fact sold this work twice, and in their own provenance listings for the artwork, they had listed different provenance information the 2 times that they had sold this. So they didn't even have, suggesting that they didn't even have an internal system in place to check their own records with respect to what they were publishing for the provenance. With dealers, there's also no obligation to supply provenance information, but again, if you supply it, it should be correct. And if it's not correct in some respect, presumably a purchaser could have a claim against the seller if they were able to prove that there were some damages that flowed from that, which might not be possible. It would really depend on the circumstances in question. And certainly the Dealers Association, the ADAA, which is the main dealers association in the States, has a code of ethics which provides that any seller in the association, when they're supplying an invoice or otherwise supplying information in connection with a transaction, has the duty to have that information be correct.
Thank you, Amelia. The next question is, what weight do artists' committees place on provenance when deciding whether an artwork is authentic? Given the number of artists' committees in France, I would ask Olivier if he can address that.
Yeah, sure. That's a great question and a difficult one. To determine authenticity, you have several categories of criteria. You have direct analysis of the work, connoisseurship, which is the main one, obviously. You have scientific investigation, they are expensive, and you have provenance. All of them should be taken into account. In my experience, serious committees, when they try to deliver a certificate, ask for provenance information, and this can be very useful. In practice, my view is that provenance is generally used to confirm or exclude authenticity. When you have doubt on authenticity by looking at the painting, you go into provenance and it becomes an important indicia. I will give a couple of examples. I represent an artist committee who, in a short period of time, received several dubious work from the same countries. So it was very awkward. And we checked the provenance and realized that all those provenance were similar. So that built up our case to demonstrate that the work were fakes. Other situation is not only fake works, it's also fake provenance. So you have to be very careful. And the Beltracchi case is an obvious example of very good forgery of provenance document, because Beltracchi was looking for disappeared work so he could produce documentation on the work, and on the back of his fake he would have faked the corresponding collection sticker, exhibition stickers. So even the document of provenance can be forged. And he got caught, we have to remember that, by a picture of the paintings in situation in a living room with a photograph of a woman who is dressed in early 20th century clothes, and the police forces realized that this very same lady was Beltraki's wife. So you have to dig into provenance. And often fakes come with lots of document on provenance, too much documentation, and that's suspicious. So you really have to dig into provenance. I can give another example where we had great letters dated from the 30s, and we asked for a scientific analysis of the paper, and the expert told us that the paper was made in the 80s. So facially, the document is good, but when you do the investigation, it demonstrates that it's fake. And in the very same case, we had an authentic letterhead with information about the work on the paper, but the date of the letter was 10 years later than the closing of the corresponding business. So the forger had found blank letterhead and just used them. So provenance should be very carefully verified and is a major information.
Thank you, Olivier. That's really interesting. The next question is, have professional bodies or institutions opined on best practice when listing provenance? Amelia?
Yes, the International Foundation for Art Research, or IFAR, has issued best practices, which are available on their website. So I won't read it all to you, but I'll read some of the highlights. Some of it is goes from fairly straightforward and obvious, like it needs to be recorded in a clear, organized, and complete manner. It can be listed in list or paragraph form. The sequence of ownership can be in chronological order or reverse chronological order. Importantly, owners should be distinguished from dealers or auction houses. IFAR suggests that the source of information about each owner or transaction be listed in the provenance, either in footnotes or in parentheses. And the provenance listing should make clear if there is a direct transfer between two owners or whether there's a gap, and you can do that via punctuation suggestions that IFAR has. They also suggest that you list the dates, the life dates of the owners next to each listing, and any uncertain information should be indicated by the terms possibly or probably and explained in footnotes.
Thank you, Amelia. Olivier?
Yes,
how does it work in France?
I will complete briefly. Well, the auction houses code of ethics say that if you give information on provenance, they should be correct and verified. This is not always the case. And the other main code of ethics is the Comité des Galeries d'Art guide. This is the main syndicate of contemporary art galleries. So they do secondary market, and they say that their members, so the trade in general, should try to search provenance and verify, but they don't have to disclose it. They can just disclose it if it's requested. So duty to verify, no duty to describe the provenance exhaustively.
Thank you. How has the practice of listing provenance evolved in the auction market over the last 20 years? Martin?
Well, I remember this very well because I think what people need to remember when they're looking into provenance, and particularly provenance pre-1990s, is it may seem puzzling that quite often there are big gaps in provenance, that things aren't known. And that may seem strange, but it's important also to remember that actually provenance was not a fundamental part of the auction cataloguing process, other than long ago, other than in order to sell objects. And now that all changed dramatically, because really the first thing was, I think, when the ERR archives were released, that is the archives from the Nazis operating in Paris, who gathered together spoliated artworks, and those archives were released in the late 90s. And at that point, I remember certainly most people handling works which had been around during that period realized that you needed then to start looking at the provenance of those objects during wartime in order to establish whether the names which appeared in the ERR archive also appeared in the paintings as a clue that there might be issues around spoliated art. So this was not just auction houses, obviously museums as well, and also researchers who were working for the families who'd been dispossessed. And suddenly provenance became absolutely critical, or the absence of provenance became absolutely critical as well. The second part of the equation was, I think, a little bit later on, when there was an awareness of the issues around antiquities and antiquities provenance, and many objects had been handed down through families, but also, and therefore didn't really have provenance because they were ancient by definition, but equally there were objects which had come out more recently from countries. And so with the advent of the UNESCO Convention, there was a concern that that objects of this age should be provenanced. And without going too much into that detail, the result was that certainly in the antiquities market, provenance became extremely important. So this is why in recent years, provenance has become more important right across the board. And of course, as Olivier said, provenance is so fundamental also to establishing the authenticity of objects. And where you have forgers like Beltracchi, who probably concentrate as much on faking the provenance as they did on the paintings themselves. And also in the UK, we had John Drew, who did something similar and effectively inserted fake provenance into the archives in the Victorian Albert Museum and the Tate in order to generate a sort of fake history of the paintings which he had forged. You realize that provenance has become fundamental in so many different aspects in auction houses that it simply can't be ignored.
Thank you, Martin. Very interesting. Nick, how has the practice of listing provenance evolved in the dealers market in the last 20 years?
Well, it's also definitely evolved over the recent years. I think it's fair to say that many more dealers will include provenance if they have it. I think one of the much repeated comments today is that it should only be included if it's correct, if you know it to be correct. And so quite often it can be frustrating if there's a link is missing between one collector and another, but it's essentially better to leave that absent and just include what one knows is correct. More and more dealers are including that. And of course, as we've heard as well, that the more illustrious that provenance is, the better reason to include it. I was asked whether whether contemporary or modern dealers are more likely to include provenance than old master dealers. Well, sometimes one might say that a contemporary dealer would include more provenance because particularly for a young artist whose reputation maybe is improving, if the work has been owned by an important collector, obviously that adds luster. With old master paintings, obviously that dealers will try and include as much as they possibly can, but there are often many links missing. I mean, clearly, while not a subject for this particular panel, the issue of wartime provenance is obviously critical, and that's probably the area that anybody dealing with pre-war paintings focuses on more than ever. But in general, I'd say that most dealers will try to include provenance if they know it's correct.
Thank you, Nick. Amelia, would you say that it's now best practice to include in the provenance dealer sales and auction sales?
Well, many of you in the audience may be more versed at this than me, so I don't feel confident in saying what is best practice, but certainly if you are including dealer information, just to go back to what I said about the IFAR best practices, then you should indicate in the provenance listing that they are not the owner, unless they really are the owner. because provenance is really chiefly about the ownership history of a work. Having said that, we do see in the market catalogs listing auction house sales even when they don't know the owner of the work, and also even listing an auction offering when the work was bought in or withdrawn. Some may question whether all that information really belongs in a provenance listing because, again, it's about ownership history, but there may be a potential benefit or upside in doing that in terms of transparency and having a repository for information about the trajectory of an artwork in the market.
Thank you. And Nick, finally, the audience might wonder, why do individual members of the trade have a different approach to provenance listing? And would it not be possible to work towards a standardized approach?
I think it's very difficult to produce a standardized approach. I mean, essentially, as I said in the previous question you asked me, the most important factor is that the information is correct. And SLAD certainly advises members to only include what they know has indeed been verified. To standardize it, I think, is very difficult because of the range of paintings that that dealers will offer. As I said, you know, if you're offering a 15th century gold ground picture, it's going to be very difficult to do a sort of clean link of all previous owners through to now. So it's obviously including as much as one knows, but obviously the information becomes much more grey the further you go back. Quite often, as I said, with contemporary dealers, they're more likely to include as much information as they have. In general, I think we've seen, as I said, greater transparency, but as you know, fellow members of the panel have all said, I think it's the most critical aspect is that the information is correct, and that as I think is probably the closest we can get to standardizing. Thank you,
Nick. That brings us to the end of this presentation. Amelia, Nick, Olivier, and Martin, huge thanks for sharing your knowledge and expertise with our audience today. It's time to hand over to the audience for questions.